A government has three arms, each of which perform an important duty for the people: the judiciary, the legislature, and the executive. We've already discussed the Indian judiciary in one of the previous videos. In this video, we shall discuss the other two arms of the government. In India, the doctrine of separation of power does exist, whereby the immense power that comes with running a country is not concentrated in the hands of one authority or person. It is distributed among the three arms of the government. Despite the separation of powers in India, there is an overlap between the persons who are in the executive and those who are in the legislature. In fact, if you look at it, the executive is entirely made up of people who are also a part of the legislature. The question is, who comprises of the legislature and who comprises of the executive? The legislature, that is the lawmaking body of our country, is comprised of the Lok Sabha or the House of People, the Rajya Sabha or the Council of States, and the President. The executive body, that is the body that is tasked with the implementation of the laws, is comprised of the President, the Vice President, the Prime Minister, and the Council of Ministers. The President of India is the de jure head of the Union Executive. De jure means something that is legally recognized. However, the majority of the power of the President is exercisable only on the recommendation of the Prime Minister and his Council of Ministers. This is because the de facto head or the head by fact of our executive is the Prime Minister. Article 52 of the Constitution says, there shall be a President of India. Article 54 of the Constitution gives for the election of the President. The President of India is not elected directly, like the members of Lok Sabha are elected. The President is elected indirectly, through the directly and indirectly elected representatives of the people of India. The reason behind such indirect election is that the Constituent Assembly believed that a direct election of the President would mean loss of money, time, and energy. As such, the same is lost even for the Lok Sabha elections. However, the loss of money, time, and energy would be worthless when it comes to the election of a president, because the president is given very little authority by the Constitution. It would be contradictory if the president is directly elected and then given such little powers. Article 54 of the Constitution provides that the president shall be elected by the members of an electoral college, which consists of the elected members of both the houses of the parliament, the elected members of the legislative assemblies of the state, the legislative assemblies of Union Territory of Puducherry and the National Capital Territory of Delhi are also a part of the Electoral College. Keep in mind that only the elected members of all these bodies are to be a part of the Electoral College. Article 58 of the Constitution gives for the qualifications which are required to become the President of India. The qualifications are that the President shall be, firstly, a citizen of India. Secondly, he shall have completed 35 years of age. Thirdly, he must possess the qualifications to be elected as a member of the Lok Sabha. And finally, he must not hold any office of profit under the union or state government or any other authority. Office of profit shall mean any position that is salaried or that shall result in any financial gain to the holder of such office. This means that while the President should be qualified to be a member of the Lok Sabha, he should not actually be a member of the Lok Sabha. Article 56 of the Constitution prescribes that the term of the President shall be 5 years. In the event that the President wishes to resign, the President shall address his resignation to the Vice President. The President may be removed by impeachment. In India, so far no President has been impeached. However, the Constitution has provided for the procedure of impeachment of the President. This is provided in Article 61. The only ground given in the Constitution regarding the impeachment of the President is that he should have violated the Constitution. In order to impeach the President, either House of the Parliament must move a resolution after 14 days of notice in writing. The notice should be signed by at least 1/4 of the total number of the members of the House. The resolution should be by a 2/3 majority of the total membership of the House. Once the resolution is passed, the same is preferred to the other House of the Parliament, who shall investigate the cause of such impeachment. The President has the right to appear and defend himself in such investigation. After the investigation, the House to which the resolution is preferred shall vote, and if two-thirds majority of the House believe that the resolution is valid and sustains the same, the President shall stand impeached. Article 53 vests the executive power of the Union to the President, who shall exercise them directly or through his subordinates. In accordance with the Constitution of India, the executive power of the government means the power to execute all laws that are passed by the legislature. This is not, however, a wholesome view of the current function of the executive, owing to the expansion of the government responsibilities and instrumentalities. The executive power of the government basically means carrying on the business of the government and the administration of the state. The President is bestowed on with various powers, the first one being the administrative power. The administrative power of the President shall include the fact that he is the formal head of all administration and that all executive action is taken in the name of the President only. He has no functional control over the various administrative departments. Those are controlled by the respective ministers. The administrative power of the President includes the right to appoint and remove the Prime Minister of India and the Council of Ministers, the Attorney General of India, the judges of the Supreme Court and the High Court, the governors of state, the Election Commission, etc. In making all these appointments, the President has to consult, and by consult I mean comply, with the recommendation of appropriate persons. The second power of the President is the military power. The President is the Supreme Commander of the Armed Forces of India. The declaration of war is done in the name of the President of India. Like most of the powers of the President, this power is merely titular, and the President holds no actual power regarding the military of India. The third power is diplomatic power. The President is entrusted with representing India as its head of state and with receiving other heads of state. The international treaties that India is a signatory to are all signed in the name of the President. The fourth power is the legislative power. The President has the right to summon and prorogue both the houses of the Parliament. In addition to that, the President may also call for a joint sitting of both the houses in case of a legislative deadlock. The President may nominate 2 members to the Lok Sabha should he believe that there is inadequate Anglo-Indian representation. He may also nominate 12 members to the Rajya Sabha, who shall be persons having special knowledge or practical experience in respect of literature, science, art or social service. The President shall recommend the introduction of a money bill. Without such recommendation, a money bill cannot be introduced in the Lok Sabha. All these powers of the President are utilized by the President on the Council of Ministers. However, there is one power of the President that he may utilize on his own discretion. That is the power of veto. The President has to give assent to any bill for it to become a law. The President can sign the bill as presented to him. He may return the bill to the legislature for reconsideration. If the bill returns to the President unchanged, the President is duty bound to sign it. However, if the President wishes to, he may use pocket veto. This is not a specific power given by the Constitution, only a power that has been created by the loopholes of the Constitution. The President is under no obligation to give assent to bills, not being money bills, within a certain amount of time. The President may use this unlimited amount of time to avoid signing a bill. If the Houses of the Parliament are not in session and the President believes that there exists a situation which requires urgent legislation, the President is allowed to promulgate an ordinance. The ordinance will have the force of a law until one of the Houses of the Parliament meets to pass a bill or until 6 months of promulgation of ordinance. The fifth power of the President is the judicial power. The President has the right to grant a pardon, reprieve, respite, remission, suspension, or commutation of the sentence of a convict. The majority powers of the President may be exercised in accordance with the advice of the Council of Ministers. The President may appoint the Council of Ministers only on the advice of the Prime Minister. The provision which made it constitutionally mandatory for the President to seek and act on the advice of the Council of Ministers and the Prime Minister was not provided in the Constitution originally. It was added in the 42nd Amendment. However, the 42nd Amendment Act did not change anything as much, seeing as the President had always been considered a titular head of the country, and judicially it was an established position that the President was to act on the advice of Council of Ministers only.